have it. Okay, right. If this is how it works, then you're recording this meeting. Be sure to let everyone know that they're being recorded. Everyone, you're being recorded. Let's take it. All right. Basic concepts of patent law. You're going to have to forgive the real Stone Age graphics that I tend to use, but you know, that's called new tricks, and I'm an old dog. So here we go. Okay, so if we talk about intellectual property, you guys will know this because you've all done your PTL course. Is this coming through? Okay, I'm getting a little bit of feedback, but is everything all right otherwise? Can I ask you all to mute your microphones? And then I think it might help with the feedback. Yeah. Okay. Oh yeah, that's definitely better. Fantastic. Okay, and you can all hear me. Great. If you can't, just jump in. Don't feel shy to interrupt me or anything. That's fine. This is interactive. This is not a one-way street. So here we go. Right, intellectual property. So intellectual property is property, just like a house or a car. But the difference is a house or a car is tangible. It's made from bricks. It's made from metal, rubber, plastics, etc., etc. Intellectual property is intangible in the sense that it is a product of the intellect, and it began its life between somebody's ears. All right. So you build a house from bricks, you construct a car from metal, but patent intellectual property is somebody thinking. Okay. And as such, your ideas are intellectual property. Now, we all know about the big 5 game species when we go to the game reserve. You know, we see lion and rhino and all the rest of them. But within intellectual property, there's the big 5 as well. And so if intellectual property is considered the broad genus, like mammal, then the species of intellectual property are patents, registered designs, copyright, trademarks, and know-how. Those are the big 5. Okay. There are other species of intellectual property, like plant breeders' rights, which protect varieties of fruit and flowers and vegetables. You know, like when you buy oranges at the supermarket, they'll often have a little sticker on them which gives a name, and watermelon and seedless watermelon and blue roses and things like that. If you breed them, you can get protection for them. But it's a much smaller species of intellectual property compared to these big 5. These big 5 are the ones that we all deal with on a daily basis, whether we know it or not. Okay. And basically, you know, a sort of textbook definition of intellectual property is intellectual property law protects the products of the intellect which are capable of commercial exploitation. Okay, wow, that's great. It's not particularly helpful, but you'll understand, you'll see how that works in the fullness of time. Okay. Right, let's just talk about each of those 5 species in a little bit more detail. Patents protect ideas in industrially realizable form, protects new products, new process, or new use of product. That's not a particularly good definition. Look, a patent protects a technical solution to a problem. So problems afflict society, whether it be diseases, whether it be more efficient ways to catch mice. These are problems that we have. And if, as a member of the community, if as a citizen of a state, you solve that problem, be it by inventing a COVID vaccine or inventing a more efficient way to catch mice, if it solves the problem in a new and non-obvious way, then you get rewarded with a 20-year monopoly. Okay, so patent law is actually an incentivization to solve problems. The government can't solve all problems. In fact, most governments could solve very few. So they sort of push that onto the citizens to say, come up with something, and if you manage to solve that problem, it's in everybody's interest, and to say thank you, we'll give you a 20-year monopoly on it. So that's the fundamental philosophy behind patent law, and we'll come back to that a lot. Okay, so don't worry if it's a bit of a slippery concept and you haven't got your head around it at this point in time. Don't worry, we'll be revisiting that one a lot. Okay, so basically, patents protect how something works. All right, and this is compared to registered designs, which only protect the outward appearance of industrially produced articles. Okay, so you think, well, why would you want to do that? But you know, there's a lot of examples where design law actually brings a lot of value to something. So, for example, think of those Smeg kettles. You know, you would have seen them on Take-A-Lot, and a kettle is a kettle, right? I mean, it's you put water in, it's got a heating element. You plug it in, boils your water. Yeah, you can get like a like a kettle for $500 from Game. Why would you pay 2,500 Rand, 5 times as much for a Smeg kettle? Because it looks cool, okay? And people will pay for stuff that looks cool, okay? And that is what registered designs are all about. So we've all got phones. I'm an iPhone kind of guy, but you know, we've got Samsung, we've got Huawei, we've got them all, and they all have they're all covered by registered designs because they all have a slightly different look and feel, and people gravitate to that. Now there's dozens and dozens of patents on your mobile phone on how the electronics work inside. That's patent law. But what it looks from the outside with the cameras at the back, the configuration of the cameras, the pattern, the fact that it's just smooth glass, there's no home button anymore, those are all registered designs. Registered designs cover kettles. Registered design covers shampoo bottles. Registered design covers cups and all sorts of things. If it's a cool new shape, you know, like wing mirrors in cars and things like that, then that's registered design. So it's big business, and it shouldn't be just discarded. So patents protect how something works. Registered designs protect the outward appearance of industrially produced articles. Got to be industrially produced. So it doesn't. Registered designs don't protect statues or things like that. That of course falls into copyright because there are artistic works and there's only a limited number of them. As soon as you have a production line pumping out these statues or whatever, on an industrial scale, registered design is the applicable legal system. Okay, I don't need to tell you guys anything about trademarks because you have all done the course and you have all passed the course. So I have, in so doing, demonstrated a competency in trademark law, and you know that they are badges of origin and they serve to identify your products and distinguish them from those of your competitors. Coke versus Pepsi, Audi versus BMW, and so we go. Okay, and so they're just badges of origin, they're points of distinction. Copyright, of course, we know as well because you've done that semester, protects artistic or literary works, no merit required. And that's really just, you know, again, you guys probably know more about copyright law at this point in time than I do, you guys having recently done the semester, and me not something that I deal with a great deal in my day-to-day. The fifth and the last of the big five is something called know-how. And this is an unregistered body of confidential or proprietary knowledge developed over time, which results in an optimized product or process. It usually resides with key personnel and is only of value whilst confidential. This is probably the most common and ubiquitous species of intellectual property because all companies have know-how, okay? It's how they do things that's not commonly known. You know, the more efficient way to you know, mix a product if you're making paint or whatever, the addition of the different ingredients, the temperature of the pot that you're mixing them in, the rate of rotation of the stirrers, that's like in a technical area. But even like if you sell insurance, you know, you will have a database of, oh, John McKnight, you know, he's got 2 kids, 1 kid is at university, phone him up, hey, John, let me, how's Alice doing? Oh, yeah. I see she's at UCT this year. That's great. So, you know, it's just how you do your job better, how you do your job more efficiently. And it's a body of knowledge. It doesn't have to be written down. It just exists somewhere. But it's of huge, huge value to people as to how they do their job more efficiently, how they do their job better than they might otherwise if they weren't in possession of that information. So know-how is it's usually confidential, so it has to be managed, right? So that's why when you join a company, one of the major paragraphs in your contract of employment will be confidentiality, where they say all these things that you're going to be exposed to here when you work for us, you can't walk out the door and take that information with you, right? It's valuable to us. It's how we do our job as well as we do. We'll share it with you because you have to do your job. But when you go, you've got to keep it confidential, and you undertake to do that. And that's called managing intellectual property, managing know-how, because intellectual property are assets, right? They're like houses, they're like cars, they're things that have value, and they need to be protected and they need to be managed. Okay, so now we've got these big five, but let's just see how they all hang together on a very arbitrary everyday sort of product. So this is intellectual property in a typical fast-moving consumer goods product. Okay. Now, fast-moving consumer goods can be anything from over-the-counter medicine to rice, to soup, to deodorants, it's just the stuff that you find on the shelf at Pick and Pay, and it just moves quickly like that. You buy it and you use it up and you go buy it again. Okay, so I'm not too sure if any of you have ever had occasion to take Gaviscon, but I can assure you that when you're in practice as an attorney, you will take it quite a lot, because it's a over-the-counter medicine that prevents or ameliorates, makes less heartburn. And of course, heartburn is where your stomach contracts because you're under stress or you're scared or whatever, and it shoots that acid up into your esophagus. And that's very unpleasant, because your stomach is adapted to have acid in it. That's how you dissolve your food, right? And the inner lining of your stomach is covered with a thick layer of mucus, and your stomach cells basically produce acid, which goes into your stomach and digests the food that you eat. And when it passes into the intestine, the pH starts changing, and your intestine starts expressing chemicals that dampen the acid, but your esophagus is not protected, right? So you've got a little sphincter at the top of your stomach that is supposed to keep the acid in your stomach, but sometimes that sphincter is compromised, or you're stressed, or very often when you're pregnant and the baby is pushing back on your tummy, that acid comes up into your esophagus and it's very sore. I'm sure all of you would have had heartburn in the past. It can be caused by alcohol, can be caused by foods that don't agree with you, can be caused by stress, pregnancy. There's a lot of things that cause it. What Gaviscon does is that it's made of seaweed, believe it or not, and they've extracted the long chemicals chains from the seaweed, and when you drink it, it floats on top of your stomach contents like a raft. And so if it gets pushed up into your esophagus, it's the Gaviscon that comes up first, and not the acid. And then the Gaviscon coats your esophagus, so the acid doesn't actually get in contact with your esophageal cells, and there's no pain. So it's really good stuff, right? It's been on the market for years and years and years, and they sell millions of bottles of it every day in South Africa, in the UK, in the US, everywhere. Okay, so the technology is old, the technology is known, but there is still a lot of intellectual property that resides in it. And it's, for example, the formulation itself is covered by patents and know-how. So you will see that the Gaviscon brand is revamped every couple of years. And that's because they will have nipped or tucked the formulation. Maybe they've adjusted it so that they can get more concentration of the seaweed in. Maybe they've made a new flavor, which is patentable, whatever. So there is usually a patent on the formulation, particularly the most recent formulation. The older ones, things come off patent because patents only last for 20 years, and then anybody can make and sell them. But they will try and push consumers onto the new variants of Gaviscon because they can make more money, because they can charge more money for it, because there's no competition, because it's the subject of the patent and they have the monopoly on it. So that's obviously how they will try and do it. So they'll put a lot of marketing behind the latest version of Gaviscon, the latest flavor, and they'll sort of spend a lot of time trying to tell you of the benefits of this compared to the first one. But of course, anybody can make and sell the first one, and there are lots of generics for Gaviscon which are based on the earlier formulations. It's the latter formulations which are the subject of a patent. There's also know-how, and I touched on it earlier. This stuff is actually quite difficult to make because you've got to get the concentrations quite right. Otherwise, all the seaweed sinks to the bottom, and then you get this clear liquid on top, and nobody likes that. You have to shake it to reconstitute it. It's not cool. So there's a lot of know-how that goes into how it's actually made, the speed of the mixes, the temperature. If it's raining, you make some adjustments, etc., because it's cold, and so on. And so, there's a lot of technology that goes into it, which not everybody knows, but the factory operators know. Okay, so that's the formulation. Then you've got the bottle. Okay, now you'll notice this bottle is shaped a little bit like a dumbbell. And sometimes those were the old bottles. Then they made the new bottles, which are shaped like a V, to give the impression of a healthy chest, a subliminal impression to the consumer when they reach for the bottle that's shaped like a V. Then they think, oh, I'm going to be healthy. There's going to be no pain in my chest, and so on. And so the shapes of the bottles are all protected by registered designs. Got nothing to do with the formulation inside, got everything to do with the actual shape of the bottle. And of course, if you've got a new and exciting shaped bottle, for example, a shampoo or a nail polish or whatever, that can be the subject of a registered design. The label design and the instructions, these are of course works of art, and they are protected by copyright. So the picture of the guy with the meteorite in his chest, it doesn't have to have artistic merit. That is never going to be hung on anybody's wall, I can assure you, as a work of art. But it is still the subject of copyright protection, as well as the wording of the instructions. As long as it's not required for use in the trade, and it's got some degree of originality to it, you can protect it by copyright, which means you can stop others from sort of slavishly just copying it. Okay, and then finally, the Gaviscon, the word Gaviscon, Gaviscon Advanced together, the logo, the font, and the colors. They're all registered trademarks, right? So nobody can use the word Gaviscon, nobody can use that particular color of teal, nobody can use Gaviscon Advance, either in that font or simpliciter. So you can see that there's a lot behind protection of the word Gaviscon. And so you can see just how even the bottle cap can be protected by a patent, a utility model, or a design rights. You can see that it's got a skirt and it's got those little folds in the skirt, so that could be a subject of a registered design. You see it's got a tamper indicator, that little red line. When you open the bottle for the first time, that'll crack, break off and drop onto the shoulder of the bottle, and then you'll know that that bottle has been opened. So it's a tamper indicator. That could be the subject of a patent. A utility model is something that we don't have in this country, but countries like Germany and other countries have them. They're sometimes called petty patents. They're just little things that they kind of don't meet the inventive step or novelty requirements of patents, but there's still something to them. It's kind of like a hybrid between a design and a patent. You won't be examined on utility models, but you just have to understand that these kind of petty patents, these hybrid models, exist in some countries like Germany. And that would be perfect for something like a bottle of Gaviscon. So you can see just a very average bottle, nothing special, and it's just absolutely bursting with intellectual property. All 5 of the species are evident in that bottle of Gaviscon. And this is true for every product on the shelf, whether it be a bottle of coffee, a bag of rice, or a bottle of shampoo. There is intellectual property in the formulation, in the name that they call it, the shape of the bottle, the instructions that go with it. There's intellectual property. It's everywhere. So it's really important to understand how it all fits together. So I hope that was sort of instructive in giving you some sort of giving you some context as to how it sort of works. Okay, let's see if I can. Why is this no? I need to. Sorry, I just seem to. Oh, there we go. Right. Now, having spoken about how they all fit together, we are actually going to start talking about patents per se for the last half an hour. So what is a patent? This is a pretty cool definition that I use. What is a patent? An agreement between an inventor and the government of a country in which the inventor agrees to publish his or her invention, and in return, the government agrees to give the inventor exclusivity on the use of the invention for a limited time. So that's exactly what we were talking about earlier, right? The problems which affect society, the government can't solve all of them. It encourages individuals and companies to come up with solutions. Solutions are often very expensive. You have to do R&D, etc., etc. And so in return, if you offer a solution, then the government will give you 20 years of exclusivity on the use of that invention, which is basically the right to exclude others from using that invention. And that's the quid pro quo of the deal. You give me the solution, I'll give you the monopoly for 20 years. And so that's the philosophy behind patents, and it's actually set out in Section 45 of the Act, and we will go into that. Okay, so what do patents protect? They protect underlying inventions, solutions to problems, and they can be things like machines, they can be new products. Now, this is what I do, sort of chemical compounds, so that could be a drug, that could be a new pesticide, that could be a new cleaning agent, etc., etc. So new products, and of course, new processes as well. If you add A to B, mix it, heat it for half an hour, take it out, put it in the freezer, you know, a series of steps as to how you make something. And those steps are new and involve a better product. It could be a new way of making a known product, so that's important. But if it's just an improvement, you don't use as much energy, you make it quicker, you make it without so much mess, then any advantage like that, that'll be sufficient for you to get a patent on that new method. Okay, now there are a couple of conditions, right? Terms and conditions apply to this deal offered by the government in terms of, you know, if you want your 20-year monopoly. And the most important criteria for patentability is novelty, okay? Now, you wouldn't have come across novelty because I don't think it's really a big thing in trademarks or copyright, but novelty means that when you come up with your idea, when you come up with your invention or your solution, it must never have been made public in any way. For example, by oral disclosure, by use, trial, printed publication in any language, anywhere in the world, before the date on which the application for a patent is filed. Okay, so it's got to be absolutely new. That's like a really high hurdle to overcome. It's a big burden. When you think about it, you've got to be the first person in the history of humanity to have come up with this idea. So it's a big deal. And if it's not novel, it's not patentable. End of story. It's a very black or white investigation. It's either been described in a prior publication or it hasn't. You're either novel or you're not. And that's something we'll look at quite closely. So novelty, absolute novelty required in South Africa. The next one, if you pass novelty, then you've got to start talking about inventive step. And this is a lot more gray, okay? This is a lot different to novelty. Novelty says, has it been disclosed before? Yes or no. Inventive step says, is it obvious or not? Okay, so this is where the argument really comes in for patent law. Arguing whether something is obvious over what has gone before or whether it's not obvious. So let me give you an example, okay, of obviousness versus novelty. Okay, imagine that we lived in a fictional world where we knew all about bicycles, but there were only one color. All the bicycles in the world were red. There were no other colored bicycles around, okay? You came up with the idea of a green bicycle, okay? And you applied for a patent for a bicycle which is green, okay? Now, they would look at it and say, is it novel? And the answer to that is yes, it's novel, because no document, nobody has ever thought of taking a red bicycle and painting it green. There's no description of that before. It's new. Okay, so you satisfy novelty, but then you come down to the next inquiry, inventive step. And the question is a green bicycle obvious over a red bicycle? And then you have to sort of think about it. Now, on the one hand, you could say it's trivial, right? You take a known bicycle and you take green paint and you just paint it, and now you've got a green bicycle. So what you've got to try and do when it comes to obviousness is you've got to try and link the point of difference with a technical advantage, because then that will win the argument of whether it's obvious or not, okay? Because it might be a trivial difference, but if it has a big technical effect, then we're talking patentability. So then you would be arguing stuff like, oh, you know, red bicycles, 3 in 10 red bicycles get stolen, but only 1 in 10 green bicycles get stolen. And that's because when you put them on the lawn, when you finish riding them, people walking by don't really notice them, or you can hide them in the hedge and people won't see them in the hedge. So, you know, I've got this demonstrable difference in the rate of theft of red bicycles versus green bicycles. So green bicycles have a technical advantage. They don't get stolen as much. And that is the kind of thing that they're looking for. You're going to argue the advantage of the difference in inventive step. And so that's how it works. But as you can imagine, that can be a long argument that you have to set out in writing, and the guy might not agree with you, and you've got to have data behind it. You've got to show statistically speaking that green bicycles don't get stolen as much, etc., etc. So arguing inventor step is by far the most grey area of patent law. It's the most meaty area of patent law, and that's where all the drama comes with putting these things together. So there we have it. Novelty and inventor step. There are a few other requirements of patent law that we will talk about. For example, they must be capable of use in industry. There are a couple of exclusions from patentability, which we will explore, like, for example, it can't be a mathematical theory, it can't be a method of presenting information, can't be an artistic work, etc., etc. They're specifically excluded. You can't patent technology which is against the public good. So you can't patent letter bombs. You can't patent articles of things that you'll use to torture people. You can't patent anti-personnel landmines. These are all things that nobody really wants, right? And the whole idea about patent law is that it's supposed to uplift the community. It's supposed to uplift the citizens of a country. New and effective ways to kill people don't really uplift society. So you can't really get patents for that kind of weaponry. It's a fine line, because you can get patents for body armor, you can get patents for guns, because they can arguably be used in defense. But there's no argument for instruments of torture. There's no arguments for letter bombs and things like that. And I think that's right. You know, I can see how you're not going to be encouraged to innovate in the area of torture or letter bombs, but you might want to innovate in the area of defense, because it's better for your community. So, you know, it's an interesting discussion that we have about it. So those are the requirements for patentability. So when you look at what a patent actually comprises, and I will send you an example of a patent, because they're reasonably interesting documents, and they tell a story, right? So a patent specification is what a patent attorney puts together, constructs, and that forms the basis of the application, together with all the documents saying who the owner is, who the inventor is, you know, this, that, the next thing, have I paid my fees, and whatever. There's a whole formal side that goes with patent applications. But substantively speaking, this is what a patent law comprises, and they're all built around the same template. They're all built around the same sort of skeleton, and that is a brief description of the technical background. So it would begin, this patent application relates to bicycles. In particular, this patent application relates to green bicycles. Then it'll be a brief explanation of the problem that the invention is going to address. And it'll be a blurb about, you know, we all know red bicycles and they're great and they served humanity well, but there's a very high theft rate of red bicycles, and this invention is looking to address that. And then a short statement of the invention. In relation to the above problem, our proposed solution is to paint the bicycle green. So this invention relates to a green bicycle. And then we'd go into more detailed description, because, as you might imagine, the first thing they're going to say is, what's green? Now, we all know certain things are green. My coffee mug is green, right? But you might be able to see that there are certain shades of green. And you can also see that my shirt has got some green in it and different shades of green. So where does green begin and yellow end? Or where does blue begin and green end? So there's a spectrum of what constitutes green, right? So as a patent attorney, you've got to try and define that, what constitutes the color green. Now, luckily, believe it or not, there is in fact a system for classifying colors. It's called the Pantone system. And it's this big book, all of different pictures of colors that move gradually through all the colors of the rainbow. And you can say Pantone grid reference X to Y. That's what I consider to constitute green. And that's sort of how we go. So there are ways and means of defining things which are in patents, and patents are all about definition. Melissa, you have your hand up.
Sorry to disturb you, Prof. Sean just sent a message stating that she can't access the meeting anymore, so she'll watch the Blackboard presentation. She'll watch the presentation on Blackboard.
Okay, 100%, no problem at all. No problem at all. Thanks for letting me know. Okay, so we were talking about the detailed description of the invention, and inventions often have drawings. If they're technically complex, then they have drawings, and I'll be able to show you some of those because you have to explain the invention. Obviously, you need to set out examples to show how it works, because one of the things required for patentability is that it must work. You can't have these wild inventions about a pencil adapted to fly to the moon. You've got to teach people skilled in the art as to how this thing works, right? You can't just have this crazy idea and have no idea how it'll work. It's got to be utile, which means to say it's got to work. And if you can prove that a patent application doesn't work, you can have it revoked. So that's a very important aspect of it. That's why examples are so important. You can say, look, here's one I made earlier. It works. Then it ends with claims, which define the invention by setting out the distinctive technical features, right? And claims are what define the monopoly. And so, do you remember in the old days of sort of gold and diamond mining, when the 1820 settlers arrived, and they pitched up and they literally roped off an area, and they said, all the gold in here is mine, okay? And if you put your foot over that rope, I'm going to blow it off with this here shotgun. It was how it sort of worked, gold prospecting and diamond prospecting. Patents are exactly like that. There's a technical platform, and you've roped off an area of platform. You've actually built this area of platform, and you say, this is my contribution to the platform, and nobody else can use it. And the claims define that area of the platform. So they're very, very important. And we'll discuss claims in some degree later. They define the area of the monopoly, the ambit of the monopoly. So that's quite important. And then drawings, as I've mentioned earlier, and then an abstract. An abstract is just because so many people are looking through your patent and looking for your patent, you need to have an abstract, just like with any paper, really, so that you can give people don't have to read the whole thing to get the gist of it. And that's what an abstract on a patent is for as well. It's very important as well. Okay. Claims they define the ambit, and they also define if the patent is infringed or not, okay? So a claim can only be read onto, which is another way of saying infringed, if all the essential integers are satisfied in the product or the method in question. And only valid and enforced claims are infringed. If it is unclear if a claim is invalid or enforced, but all integers are satisfied, claim is said to be read onto. So patents, like trademarks, have to be renewed periodically. Trademarks every 5 years, is that correct? Somebody nod, please. Yes, 5 years renewal. Patents every year. Okay. So if you don't pay your renewal fee, then your patent lapses and you won't be able to sue anybody for infringement. Likewise, if somebody can prove that your patent is not novel or not inventive, it gets revoked and it's not valid. So you can't enforce it. You can't assert it against anybody. So only patents which have all their annuities paid up and which are found to be valid can be infringed. Otherwise, the patent is just read onto. So what you look at claims is when you look as to whether a claim is infringed or not, you break it up into integers. So if we look at our claim, a bicycle which is green, it's got two integers. It's got to be a bicycle and it's got to be green, okay? And then each of which is compared to the product in question. So if somebody comes along and they make a unicycle, which is green, that doesn't satisfy all the integers. It doesn't satisfy the first integer of being a bicycle, right? So you can't say the claim is infringed because not all integers are satisfied. If you have a bicycle which is red, again, not satisfied. It's a bicycle, all right, but it's not green. And so it works. So you've got to be very careful when you draft your claims about, like in this claim, if I said bicycle, then tricycles and unicycles wouldn't be caught. So maybe I want to say a wheeled transport, which is green. But then I might include cars, because cars are wheeled transports. So difficult. So you might say a unicycle, a bicycle, or a tricycle, which is green. So you can see how you can draft your claims to avoid the prior art, to avoid that which is known, because green cars are known, but to carve out an area of monopoly which is not known. And that's a bit of a dark art. And that's one of the main skills of being a patent attorney, is trying to get that right. And it's not something you can really be taught. It's just something that you kind of develop a skill for the more you work with it. Comes with familiarity of drafting patent specifications. So you break the claim into integers, a bicycle, which is green, and then if the integers are present, all present in the product or method, then further investigation into the validity of the claims is warranted. Okay. If not all integers are present, the missing integer must be scrutinized to see if it's essential or not. So it's not like they thought, oh, that's a difficult enough concept as it is. What they decided to do was they decided to give the patent attorneys a little bit of a break. And they said, if the integer which is missing is not essential to the invention, then you can possibly still infringe the claim, even though you didn't satisfy that integer, because that integer is not essential. So that's called the doctrine of purposive construction. We'll come back to it. But basically, it means that when you're trying to describe something in your claim, if you include a little element of it that's not essential to the invention, and an infringer comes along and builds it without that little thing in it, he can still possibly infringe, because they just felt that every integer having to be satisfied was a little bit prescriptive, as it was a little bit black and white. So they wanted to make it, they wanted to give the guys a little bit of wriggle room to see if they could maybe, you know, cut the patent attorney a break if he included something, if he included an unnecessary limitation in the claim. So that's the idea behind it. Don't worry about that now. We'll get to that in the fullness of time. I just wanted to sort of highlight that as something that is part of patent law. Okay, let's go on to the formal process of how you apply for a patent in South Africa. We will talk about applying for patents in other countries around the world, but just for the South African filing process is reasonably simple. So the first thing is that you have your idea. Okay, that's supposed to be a light bulb. And, you know, the concept of ideation. Bing, let's make a coffee cup with 2 handles. All right, great stuff. Then you go and speak to your patent attorney, and he will draft your patent specification. Just like I said, have this relates to coffee cups. Coffee cups traditionally have 1 handle. This is a problem because if you drop it, there's nothing to hold on to. But if you had a second handle, it would improve your chances of catching it. Whatever, you know. The problem that you're addressing in your solution. You draft the patent specification, the client and the patent attorney get together. Yes, we're happy with it. The drawings are great. I'm happy with it. All right. Then we file it at the South African Patent Office, okay? And we file what's called a provisional application, which just puts your foot in the door. And it says, on this day, John applied for a patent application relating to a 2-handled coffee cup. What that does, it sets in motion a 12-month priority period where John can experiment on this. He can take his 2-handled coffee mug to coffee mug manufacturers and say, you guys interested in this? Do you want a license? I've got this patent for this, etc., etc. He can improve the design. He can make different designs. Then after 12 months, he's got to file what's called his complete specification, okay, which builds on the provisional, but it includes all the improvements he's made in that 12-month period. Then there's an acceptance period of about a year where it just lies there and they go through the motions and make sure all the paperwork is correct. You paid your application fee, etc., etc. Then it gets accepted. Okay, and then within 3 months later, you've got to publish it in the patent journal, and then you have what's called your granted patent, which happens on the day that it gets published in the patent journal. And that is the document that you can start suing people for infringement for, etc., etc. You can't sue on your provisional application. You can't sue on your ungranted or only accepted application. It has to be granted, and then you can go for it. In South Africa, we also have a 9-month moratorium after grant, so that you can't straight out of the gate and start suing somebody for infringement. And that's because we've got a non-examining system in South Africa. So you can file, whatever you file for, it's going to get granted in the fullness of time. Other countries have armies of patent examiners who specialize in coffee mugs and golf balls and mousetraps and bicycles. And when a patent application comes to the door and lands on their desk, it gets routed through to the specialist, and he looks to see if it's novel and if it's inventive, and if it satisfies all the other criteria. And he will actually start an argument with you to say, listen, I've got coffee mugs here that I've got 2 handles, so I don't think it's novel. And then you've got to write back to him and say, actually, it is novel, because you'll see I've changed my claim. I've now made it that the 2 handles are red, And so, I agree that you've got prior art documents that show two-handled coffee mugs, and as such, they predate the date on which I applied for my patent, so they constitute prior art against my patent. But, mine is new because I've made this change, etc., etc. South Africa doesn't do that, okay? In the draft IP document, which is coming, we are training examiners, but COVID has really put that, it's really put that on the back burner. But there was a cohort of examiners that was coming through because South Africa wants to move to an examination system. And I think it's a good idea. And we'll be talking about that more in the fullness of time. But that's why we have that 9-month moratorium, is so that people will be able to look at a patent that gets granted and say, hang on, I don't like that. And then go and do some research of their own to see if they can invalidate it. And they'll have a 9-month period to do that before a granted patent is enforceable in terms of South African law. Okay, right. 13, patents are territorial, as you would have seen earlier. There are agreements between a government and an inventor. So if you want a patent in Australia, you have to file it in Australia. If you want a patent in the United States, you've got to file it with the United States Patent and Trademark Office. And so to stop someone making use of your invention in any particular country, you must obtain a patent in that country. Now that means getting global patent protection is a very expensive business, right? Because you need to have an Australian patent attorney working on your Australian patent application. You can't have a South African. All countries say if you want a patent in this country, you have to appoint a local attorney. It's called a local address for service. And these guys charge in the currency of that country. So they are charging in euros in Europe, in British pounds in the UK, US dollars, Aussie dollars, Japanese yen, you name it. And the South African exchange rate is like this, so you'd never know how much you're going to have to pay these guys in terms of rands at any given time. So it's pretty fraught getting patent applications in multiple countries, and it's very expensive. So it's a bit exclusionary to the man in the street because it is just so expensive. So this international patent filing programs are mainly the domain of big companies, drug companies and things like that really have to file in a lot of countries. Okay, there's no such thing as a world patent, but major supranational processes known as, for example, the PCT, the Patent Cooperation Treaty, allow for applying for patents in multiple countries. So what that basically means is a whole bunch of countries have signed up to this treaty, and what they say is a single application with this treaty will secure you rights in all of the countries that are signed up to that treaty, and then within a certain period of time you have to cement or validate those rights in those countries. So it gives you a bit of time to make up your mind about whether it's something you want to do, and it gives you a bit of time about to pay all these fees as well, because otherwise a lot of money would be payable straight up, and that can be a little bit difficult from a cash flow point of view. So and there are also, to make things easier, several regional conventions to allow for the protection in multiple countries through a single application. For example, the European Patent Convention. So most of the countries in Europe have signed up to what's called the EPC. And basically what they say there is, if you file in the European Patent Office, that's a central office, they will examine, they will grant, and when it's granted, it's valid in all of the European countries. And there's a lot of conventions that are modeled on that, and there are 2 in Africa called the African Regional Intellectual Property Organization, ARIPO, which covers mainly the former British colonies. So that's all in English, which is pretty cool. But then you also have a corresponding French one, because, the French colonized huge areas of Africa. Alex, you'd know about that. It's all up in your part of the world there. Most of those countries are French speaking, and they have something called the ORP, the Organisation Africaine de la Propriété Intellectuelle. I don't know, I don't speak French, I'm really not good about that. But you can see how single filings can secure you rights in multiple countries, often as a result of the colonial footprint, which it's just one of those things that sort of the colonists had they imported their legal systems, and they sort of left them behind when they left, and it is what it is. So that's quite an interesting aspect of geographies of protection for patent law. Okay, guys, I know I'm going through this really fast, but I'm just giving you a flavor of all the things we're going to cover. This is just a summary of the syllabus. Okay, the term of a patent is generally 20 years from the date of filing, and it's a piece of property, as I've mentioned before, on which others can intrude at their peril. So you can sue infringers for damages. They can be bought and they can be sold, and they can be licensed out. So, you know, these, just like your house or your car, if somebody crashes into your car, you can make them pay for it. If somebody infringes your patent, they will pay for that. You could sell your car, you can buy somebody else's car, you can rent a car, you can sell trademarks, you can sell patents, you can let other people use patents or trademarks by way of a license. That's like renting them out, and you can buy and sell them. So, you know, there are pieces of property straight up, and that hence the term intellectual property, right? Let's just talk about an example of patents, because this is quite interesting. I'm not sure if you guys, so my daughter has one. They're instant cameras, right? So, you know, we've all got cameras on our phones and things now, but in the old days, cameras took rolls of film, and you take photos, and then when the film was finished, you'd take it to the chemist. It would take 2 or 3 days to be developed, and then you'd get these actual physical photos back, right? And I'm sure your mom and dad will have had them, or maybe your grandparents, but you guys being the generation that you are, Lazarus, of course, will know that as well. But so now it's all digital. But what the kids quite like to do nowadays is you can get Instamatic cameras, where if you take a picture, zzz, out comes a little picture, and it develops in front of your eyes. Do any of you guys have those? My daughter wanted one for her birthday. They're pretty cool. So like at a party, you zzz, and then out comes a little physical picture, like a little postcard, and you can, after a minute or two, develops, and you can stick it on the fridge and all that. It's pretty cool. Anyway, that was invented way back in the 1970s by a guy called Edward Land, and he made this very expensive, complex-looking camera that allowed you to do these instant pictures, right? And he started what was called the Polaroid company that made these cameras, but they were very expensive, they were very complex, and they were only really for enthusiasts. But what they did was, if you look in the middle of that camera, they took cartridges of film that had 10 of these undeveloped photographs in them, and then they were sucked into the machine, and then they came out at the bottom, and they made these instant photos. And the dominant film company at the time was Kodak, right? And they looked at this and thought, wow, that is a very interesting concept. But what we want to do is we want to sell that film. So they made these cheap cameras that used to film. And so instead of targeting the photography enthusiasts, they just like made it for happy snaps on a Sunday afternoon at the braai. And so the cameras were cheap and nasty, and people were just buying the film because that's where they made their money, because that was the consumable, right? You only sold one camera, but you sold lots and lots of film. So they had a slightly different twist on the idea. But Edward Land was quite a clever guy, the guy who invented instant photography, and he had a number of patents on this. So he sued Kodak, and he was just a little guy, but he sued Kodak, and it took ages and ages and ages. It took about 10 years for the patent infringement case to move through all of the courts before it finally ended up in the United States Supreme Court, and Kodak was eventually forced to stop manufacture of both the camera and the film, and was left to pay settlement to some of its customers who were left with a way to use their now defunct cameras. So what was interesting is that when if you get found guilty of patent infringement, quite a lot happens. And that is, there's a couple of things at the winning side. The patentee, the holder of the patent, if they win, they get an interdict preventing further acts of infringement. They get damages for every camera that was sold, every box of film that was sold. They get delivery up of all the infringing goods, and they get costs. Okay, so I mean, it can be devastating when you add all of that up. You know, it really sort of can be a lot of money. And damages are calculated on a reasonable royalty or an account of profits, which is to say, you know, like what they did in this case was they said, if Kodak had had a license from Polaroid to sell that film, they would have had to pay $1, for example, per box to Polaroid for every one that they sold, right? And they sold 10 million boxes, so they owe Polaroid $10 million. But they sold the first box 10 years ago, so they've owed Polaroid dollars on those boxes they sold, which they haven't paid. So there's interest payable on that over the years, right? So it just adds up, adds up, and adds up. So in the US, and this is just something to be aware of, is that if you can prove that an infringer was willfully infringed the patent, which is to say he knew he was infringing. So if he had gone to a patent attorney and the patent attorney had said, don't do this, you're infringing the patent, that's willful infringement because you did it anyway. And then any damages award you get times by 3, okay? But that's only in the US. That's punitive damages in the US. So, but in this case, in Polaroid versus Kodak, judgment was handed down at $905 million US, okay? They did appeal it, was reduced to 873. And that was composed of $437 million combined lost profits and reasonable royalty, and then the same amount in interest because it had gone on for so long. Now, this was 30 years ago. So those figures now, I mean, when you have patent judgments now, you know, Apple versus Samsung, they're talking billions of dollars in this kind of thing. So in damages calculation. So it's very, very stressful to get your patent right, to make sure that you're not infringing anybody else's patent, and to argue these patent cases in court, because the money is enormous and it'll break a firm if they lose badly. So there can be quite a lot of pressure on patent attorneys to A, make sure that the patents are drafted correctly, and B, that they are enforced properly, and C, to advise your clients that what they're doing might infringe a valid patent. So there are 3 pillars to patent law. You've got to protect your client's rights. You've got to respect the rights that are held by third parties, and then you've got to lever your rights. You've got to chart a course so that your clients can make money on the monopolies that their patents confer onto them. So it's a very interesting way of doing things, and that's why you've got to have the technology, so you understand the technology, but that's got to be piggybacked on the law, so you know all about interdicts and damages calculations and costs, etc., etc. So it's a very interesting aspect of law, and you can see sort of how I spend my days. Okay, we've just got 3 more slides, and my last slide is a little bit of philosophy, because I mentioned at the beginning of this lecture, and you'll see it's a recurrent theme, there is going to be a lot of philosophy behind this course. And that is a guy called René Descartes. It's not Descartes, it's Descartes. And he was a French philosopher. I know he looks a lot like Jan van Riebeeck, but I think that was just a hairstyle at the time. If you look when he died, 1652 years before Van Riebeeck first set foot in the Cape. So that was what they looked like back in the day. But René Descartes was a very cool guy. He was the father of modern philosophy. He was a very good mathematician, actually. I don't know if you guys do you remember from school, if you did maths, when you did graphs, you did your X and Y planes, okay? When you drew your graph, X and Y axes. And I don't know if your maths teacher ever referred to it as a Cartesian plane, but he is the guy who invented it. You know, Descartes, Cartesian plane, you get it? Anyway, so he invented that branch of maths, so he was quite clever, but he was also a philosopher. And what he was most famous for saying was, I think, therefore I am. And how he came about that was, you know, like it was 17th century. There wasn't, they didn't have the medicines that we have today. So a lot of people died young, and he was actually a guy who he suffered from pneumonia quite a lot. And now pneumonia is a very disagreeable affliction, and you're quite lucky to survive it. And he got it 2 or 3 times in his life, and it eventually killed him. Nowadays, you just take antibiotics and you're okay, but it's still quite disagreeable to have it even in this day and age. So you can imagine what it was like in the 17th century. So during one bout that he had pneumonia, he was lying in bed and he was delirious, and he sort of imagined dragons coming out of the ceiling to try and eat him, and he was terrified and all the rest of it. But when he got better, and he was sitting in front of the fire, and he had a glass of cognac, and was in his dressing gown, and was all very comfortable and warm, and he got to thinking, and he said, you know, I'm very comfortable and warm now. The fire is crackling, and this cognac tastes delicious and I'm very comfortable. So all my senses are telling me that this is how it is. I'm warm by the fire. I can taste the cognac. I can hear the fire crackling. I can feel my dressing gown. It's great. He said, but it was equally compelling when I was looking at those dragons, right? I thought they were real. I could hear them. I could smell them. And I thought I was hallucinating, but maybe they were real and maybe they weren't. Bottom line is that you can't trust your five senses, right? You can't trust that this cognac isn't just a hallucination like those dragons were. This is just a nice hallucination. Those dragons were horrible. I don't know. They're both equally compelling. I can't trust my five senses. So how do I know I'm alive? If nothing I see or feel or touch can be trusted? Well, I guess the only proof that I'm alive is the fact that I'm having this mental conversation. I'm thinking these thoughts. That alone proves that I exist, right? Because nothing else I see or touch can be trusted. But the fact that I'm having this conversation, that's indisputable, right? So therefore, because I think I must exist, I think, therefore I am. That's the logic behind René Descartes. I think, therefore I am. And that's exactly intellectual property. Because companies, musicians, novelists, inventors, they exist because of what they have created through their thought processes, right? They've thought something up, they have created something, and that is their existence, okay? That's how companies like Coca-Cola survive. They invented the formula for Coke. That's how Apple survived. They invented the iPhone and the iPod, etc., etc. It wasn't there before they came. Their thought processes are the reason for their existence. Now, these are intellectual assets. The formula for Coke, the patents on the latest generation of iPhone, these are assets, and they have to be managed, and their value has to be recognized, and they have to be put in the right hands. And that's why continued existence, actually the business of existing, the business of I am, can be said to be intellectual asset management, because that's what we do. And that's why you are in this course, LLM. You recognize the value of intellectual assets. You need to understand them, and you need to be able to manage them. And that is why we do what we do. So that is intellectual property law and patent law in particular in a nutshell. And I think that probably brings us to the end of this lecture today. Hopefully you will sort of be able to understand how they all fit together, how they work together, and their relative importances together. And yeah, and so when we meet again on the 6th of March, we'll send everything through to you. We will begin at the beginning of patent law, and we will be going through the textbook, and I will send you the details of the textbook as well. I will email it to you, and I will upload this all onto Blackboard as well. So guys, that is the end of today's lecture. I'm not too sure if any of you have any questions or anything that you'd like to ask me before we log off. And then Alex, I see your hand. I'll come to you now. And then once we're done, we'll end off, and then over the course of the weekend, I'll upload this all into Blackboard, and I'll send you another email, and we'll see you on the 6th. But yeah, that's it. Alex, how can I help?
Hello, Prof. Thank you very much. That was an interesting lecture. Very interesting. I mean, you're opening our eyes to a number of things that we have taken for granted all these years.
Yeah.
But I just want a bit of clarification in terms of the inventive step.
Yes.
It seems to me that in addition to, proving that there's no, if you want, prior knowledge or prior art, or that it's not obvious,
yes,
you also ought to justify the technical advantage of whatever invention that you're seeking patent for.
Yes, yes. So that is the most common mechanism to overcome the argument of obviousness or lack of inventive step. But there are other ways that you can do it. For example, you can say that there is a technical prejudice that exists in the prior art, in the sense, for example, if you can find a reference that says, under no circumstances must you ever paint a bicycle green, it's very dangerous, and you do it anyway and it works, that would be counterintuitive to the teachings of the art. So you would be rewarded from a patent like that. But generally, more often than not, 9 times out of 10, you are required to show a technical advantage associated with the point of difference against the prior art.
Thank you very much, Prof. Thank you.
Lazarus.
Hi, Prof. Just a quick question in terms of process. So does it mean that you can actually lose your protection? So this thing has been confidential and you've hidden it well, etc. But then you take it to lawyers who put in the first notice to the patent office.
Yes.
But after that, then somebody else does a similar thing, or even gets to read something at the patents office or whatever. Does it mean you can lose it because you're not protected until 9 months after?
No. That's a great question, Lazarus, but what it all turns on is the very first date that your patent attorney lodged your application, your priority provisional application. That's the date that stands as the date on which Lazarus had thought of this concept on this day. And they stop counting prior art from that day. So you're only judged on novelty and inventive step on anything that happened prior to your filing. So if you filed for your patent application today, well, you couldn't do it today because it's a Saturday, but yesterday on the 19th, then the only documents that are considered in terms of novelty and inventive step are those that were published up until the 18th, Thursday. The day you filed for, they don't discount, and anything that comes after today, tomorrow, next week, you got there first. First across the line, that's the date by which novelty and inventive step of your invention are judged. It's the date of your priority or very first application, anywhere in the world.
Okay, thanks. Thanks, Prof. Understood.
Great stuff. That's for patents, right? Yeah. Okay, guys. Unless there are any other questions, we are done. Does anybody have anything else?
Nothing. Thanks, Prof. That was really interesting.
Good. I'm glad you guys liked it. And as I say, we set the platform and we'll explore most of those things that I touched on in greater detail during the course. Keep an eye on Blackboard. I'm going to email you on Monday. Things will be posted to Blackboard, and we will see you 9 o'clock, if that's okay, on the 6th of March. But again, I'll confirm all by email. Oh, by the way, feel free to create a WhatsApp group for you guys. I won't be on that WhatsApp group, so you can chat amongst yourselves. For me, email is my thing. If you want to get hold of me, email is my thing. I keep constant I watch my email like a hawk because as an attorney, that's my principal way of communicating with my clients. So I've got eyes on it all the time. If you need me, email. That's the way to do it. Okay.
Thanks, Prof.
Great stuff.
Okay.
All right. Thanks, guys. It was great to meet you. I look forward to seeing you again in a few weeks' time. And as I say, I'll be in contact. Any questions, give me a shout. Otherwise, I think that's it. Great.
Bye, everyone. Enjoy your weekend.
Bye,
Thank you,
everyone.
Prof. Have a great day. Bye.
Thank you. Bye.